Pat, you can give us a brief overview. I know Norma sent you an email, and that is when we adopted this and the people that's bringing up the constitutionality of it, I just want you to give us the Cliff Notes version of the constitutionality of this program as per your review of what we have in place.
Right. Your clarification that I received yesterday was to determine, in reference to the Red Flex contract elsewhere, where other communities or states have declared this type of enforcement procedure to be constitutional or not. I don't have access to a database that can research all 50 states. What I did do is I spoke to Red Flex, and their statistics are that automatic enforcement has never been found unconstitutional. It's in use in half the states in more than 230 cities. There have been due process challenges that have been brought but have failed. Now, where the program was challenged, in some instances with success, dealt with the interface of a local ordinance and state law. In other words, not a constitutional issue, but whether or not in a particular state it was consistent or not consistent with the state regulatory scheme on traffic. But as your question directed to constitutionality, I'm informed that it's never been held unconstitutional.
So it's never been held unconstitutional. In the latter part of what I didn't ask, but that you alluded to, this deals with it being in conflict with state law or local law. What did you say regarding that?
The instances where there have been in other states challenges, in some instances successful, deal with whether or not a local ordinance in another city, another state, does or does not comply with the regulatory scheme of the state. Minnesota is an example of that. I'm not sure if that's Red Flex or not, but Minnesota, they found that a program with camera enforcement of speeding was not in accord with Minnesota law pertinent to traffic regulation. That's an illustration.
Do we have any of those situations that exist with our current ordinance that would be in violation with Louisiana law?
The Attorney General has rendered an opinion to the City of Sulphur, and where it was considering, I don't think it was ultimately adopted, but Sulphur asked the question of whether or not a civil violation for speeding enforced by cameras was in accord with state law, and they held that it was. That was in September of this year. So there are no court decisions on it. The only thing we have is the Attorney General's opinion, which found that it was a lawful ordinance as it was structured and was not out of step with state law.
And the Sulphur decision,
Attorney General's opinion wasn't a decision; it was an opinion of the Attorney General.
The opinion of September the 4th, 2007, opinion number 07-0062.
I'm not sure the number.
And so, are there any other instances besides the Sulphur opinion that you just referenced that you think would cause us to have any concern?
I know of no court cases in Louisiana, and the only thing we have on the books is the Attorney General opinion that I allude to.
And did Sulphur go with the plan according to your information?
I'm not sure, really.
Pat, did you do any review of the constitutionality or any other legal issues that Red Flex may have had throughout the country prior to us adopting the ordinance?
No. Okay. That Red Flex might have had elsewhere?
Yeah, just to, I mean, because there are those people that, for the good that this program is doing in our city, or the bad for those people that is doing bad, and that there's this looming question that's out there that people ask and are referring to about the constitutionality of it, whether it's legal and all this other stuff. And I just think it's incumbent upon the LCG as the local government to be very clear and definitive on those types of answers. I don't think we should just disregard those people because of their opinions and who they are. I think because we are instituting this program, it has passed, it's a part of the fabric of who our community is, that we should be very forthright with them and that, yes, we want this program, we believe it's constitutional, we believe it's legal, And I just was wondering, because I was under the impression that there are these types of questions being had all over the country, and if that's not the case, so be it, but I was just under the impression that we have this discussion going on, not only in this city and other cities, and that we would want to be as definitive as possible with our citizens about where are we as it relates to this program, not just the implementation of it, but the legality of it, and what are some other challenges that other communities have had. And I just don't feel that we got that as a council when we implemented it.
We had this conversation several meetings ago, and I recall my response was that one cannot evaluate constitutionality in a vacuum. Louisiana law is very, very clear. The Supreme Court has said on numerous occasions that legislative enactments, either at the state level or at municipal level, are presumed valid, and that a constitutional challenge must be particularized. And so I do hear, we all hear, a statement of unconstitutionality, but until we focus on the particular aspect where it's, alleged to be unconstitutional. I'll give an example. You hear a lot about the right to confront your accuser. Under the Sixth Amendment, that relates to a criminal proceeding. This is not a criminal proceeding. This is a civil offense, if anything. And so I use that as an example.
Yeah, I understand you using that as an example, and I'm simply saying that as we know those things are, whether it's the top 5 or 6 things that's out there, it would seem to me that on our website or somewhere we would have a frequently asked questions or something that would just say, look, we know that this is out there and this is our response. I mean, I just feel that, it's almost like, the answer that you just gave, if we know we're right, if we know LCG is right, why not share that information with the public? If we know there's some misconceptions out there, why not share it? The other part of it is, like in the sulfur case, it states that the ruling states that state is permitted only with the written approval of the State Department of Transportation and Development. Well, did we do that? Do we have the approval of the state DOTD for the program? And I know you can't keep up with all the questions and all the answers, but I think since we've instituted this program, the citizens, I know, have some questions, some frequently asked questions, and I would just urge us to be as diligent as we can to try and just provide that information, regardless of where the person is on the issue. I think from a people's right to know standpoint, we can at least clarify it and let it fall where it's may. And I definitely understand what you're saying about what you said 2 or 3 meetings ago in reference to it's a broad stroke. I'm not talking about that. I'm just simply saying that it would seem to me that we would want to have that information out there. Now, the other part of that is that I know that there's a feeling that that's a very small population of people making a whole lot of noise out there. So if we answer those questions, we may validate it. I can tell you, Miss Angel has never been, I've been here 16 years, she's never been here. I mean, and she has a concern. I mean, and there are a lot of people like her. When I go to church, when I go to the store, people ask me about it. Not necessarily for or against it, but they want to have the clarifying information. And I would just ask that as a government, we give that to the citizens who are being affected by this program.